If you're a family member handling a loved one's estate or a professional fiduciary entrusted with real property, listen closely. Selling real estate tied to a probate, trust, or conservatorship can be full of legal and financial landmines. In my 20-plus years in fiduciary real estate, I've seen even seasoned professionals make avoidable mistakes that led to delays, legal disputes, and in some cases, personal liability. So in this video, we're diving into real horror stories, what went wrong, and more importantly, how to make sure it never happens to you. If you've ever been worried about missing a disclosure, not having the legal authority to sell, or being blindsided by a title issue, this video is for you. If we haven't met, hi, I'm Andrew Vries. I help professional and family fiduciaries sell probate and trust real estate in the San Francisco Bay Area with less stress, less liability, and for more money. I've closed over 900 of these transactions, and this channel is here to help you avoid costly mistakes. If this information is relevant to you, consider subscribing below. So let's jump in. Mistake number 1, not knowing when to sell or hold. This is one of the trickiest parts of managing real estate in estates and trusts, especially when an elder is involved. Let me give you a couple of real-world scenarios. First, an elder may not be returning home from rehab. The property they own is in disrepair, bleeding money through deferred maintenance. There's no budget to fix up the property, and rental income won't come close to covering the costs. Or let's say an elder owns a rental property with major equity but low income. They also have high maintenance expenses and major tenant issues, and the added challenge of strict oversight from, say, the Berkeley Rent Board. The building is losing money year after year. Now that elder needs to access the equity in those properties to cover senior living costs. But the family says, don't sell. We want to inherit the property. We don't want to pay massive capital gains, or this isn't the right time to sell. Let's wait for the market to peak. As a fiduciary, you're caught in the middle, and that's where I come in. I often work with clients to create a detailed rent versus sale analysis. It factors in the elder's needs, the property's current and future value, financial context, legal constraints, and market trends, and will give you a clear, well-documented tool to guide your decision. Mistake number 2, not having the legal and the title authority to sell a piece of real property. You must have the legal authority to sell a piece of property before doing anything. And believe it or not, this step is often overlooked. If you're a personal representative working under the Independent Administration of Estates Act, here's what you need to know. Full authority. You can proceed with just a notice of proposed action. Limited authority or no IAEA, you need court approval under Probate Code 10308. And if anyone objects to your notice, back to court you go. But that's only half of it. The title must be clean. I've seen attorneys forget to publish required notice. I've seen properties with broken chains of title, missing deeds, unreleased liens, and even reverse mortgages nobody flagged. That's why every sale should start with a legal document review of both the trust documents and any wills or letters of administration. You need to make sure that there is authority to sell. You want to make sure that proper notices of proposed actions are given, and at the close of escrow that comfort letters are provided to the title company. And work with your title company up front. They will check the chains of title, they'll look for old deeds, liens, and much more. Here are a few fiduciary horror stories. An attorney forgot to publish the notice of sale until after the offer was accepted. Another forgot to publish the confirmation hearing, and it wasn't discovered until the hearing date. A realtor didn't know the difference between full and limited authority. A fiduciary took on a Berkeley property with an additional parcel only to find out later it required a quiet title action. Had they reviewed the title up front, they likely would have passed on the sale. Another fiduciary discovered one brother's estate couldn't be sold because the other half of the property held in a trust was never properly transferred into that trust. The bottom line, do your homework before you list. It'll save you enormous headaches down the road. Mistake number 3, not limiting your liability through proper disclosures and deeds. Many agents aren't versed in the special disclosure rules for probate and trust sales, and that's a problem. Yes, fiduciaries are exempt from the standard trust disclosure statement, known as the TDS, but you still need to complete the supplemental exempt disclosure statement, and you must still disclose any known work to the home, especially unpermitted or non-professional work, any pertinent history from neighbors, family, or past tenants that are germane to the sale, and of course any known defects or concerns, even if they're unverified. Over-disclosing is always better than under-disclosing. You don't want surprises or lawsuits later. We also recommend pre-listing inspections by licensed professionals, home, pest, foundation, drainage, and even engineering reports, and that you put clear disclaimers on these inspections that they are for informational purposes only. And lastly, always use a title company with insurance for recordings and transfers. Mistake number 4, not understanding how the Bay Area real estate market works. This is a big one. The Bay Area is not one real estate market. It's a dozen micro markets. From Silicon Valley to the financial districts to urban centers, suburbs, and retirement communities, each market moves to its own rhythm. Add in school districts, commute routes, cultural preferences, and global financial influences, and you can't time this market like the stock market. You need an experienced local real estate expert who understands what's selling, who the buyers are, and how to price and market based on what's working now, not last year. The right guidance can protect your sale from stalling and protect your reputation from criticism. Mistake number 5, not hiring the right experts for your team. You need a real estate broker involved early, not just to sell the home, but to help devise a smart real estate strategy based on the family and financial situation, to create a clear and agreed on budget for prep and improvements, to outline the best marketing plan to attract qualified buyers, to conduct expert pricing analysis or suggest a professional appraisal, especially when families don't agree on value. But more than that, your broker should have the experience in fiduciary sales, court procedures, and the legal paperwork involved. In addition, a proven ability to work with families, attorneys, and probate referees, the experience to sell unique properties and showcase the potential of those properties, the communication skills to act as a buffer, yes, sometimes even be the bad guy with the heirs. I've seen fiduciaries run into serious issues because they hired realtors unfamiliar with probate, unlicensed, uninsured vendors, family members with licenses but not the right experience, property managers who thought they could handle the sale, or agents who didn't understand they worked for the fiduciary, not the family. Get the right team up front. It'll save the estate money and protect you from liability. Now that you've got a better handle on how to avoid the top mistakes in trust and probate real estate sales, you might be wondering about how probate and trust sales differ from real property sales. In this video, I'll walk you through how probate and trust sales come with unique legal requirements, court oversight, and additional complexities that most agents just don't have experience with. And that can cost you as a fiduciary a lot of time and money. So watch that video and I'll see you over there. Thank you.